Good afternoon, everyone. It's a beautiful day here in Las Vegas. It's April 28th, 2025, and on Friday I put out a video about the U.S. Ninth Circuit ambushing me on my preliminary injunction appeal. So a preliminary injunction motion is immediately appealable in the federal courts, and I had asked the federal court here in Las Vegas, Nevada to enjoin Clark County District Attorney Steve Wolfson and Nevada Attorney General Aaron Ford from maliciously using the criminal justice system to enforce secret and void family court orders coming out of Santa Clara County, California. The judge here in Nevada, the federal judge, denied my motion on Rooker-Feldman grounds. And the Rooker-Feldman doctrine basically says you cannot use the federal courts as a de facto appeal. But it only applies on final state court judgments where the courts had jurisdiction and you had due process and there was no extrinsic fraud. And so based on his erroneous conclusion that he could not address the merits of my preliminary injunction motion because the Rooker-Feldman doctrine barred him from doing so, I filed an appeal. And I have briefed all those issues at the Ninth Circuit. And on Friday, the Ninth Circuit came out with the decision. It was basically one page. I mean, the PDF was 2 pages, but the actual decision wasn't even 1 page. And they basically said that the judge did not abuse his discretion because I didn't prove up the 4 Winters factors. And so Winters factors come from a Supreme Court case, Winters. Those are the 4 factors that you have to show in a preliminary injunction motion. They are that you're likely to succeed on the merits, that you're likely to suffer irreparable harm if it's not awarded the preliminary injunction, the balance of equities tip in your favor, and the issuance of the preliminary injunction is in the public interest. So if a judge is going to award or deny a preliminary injunction, they have to address those 4 factors and make findings. And neither the lower court judge nor the Ninth Circuit did that. So the Ninth Circuit completely just ignored the Rooker-Feldman issue and went off on a tangent based on nothing because the lower judge never addressed those factors. So I have some options. I have the motion for a panel rehearing. So for those of you that don't know, the Ninth Circuit is a huge court and it has, I think, 20 or maybe even more than 20 judges at this point. And cases are typically heard in 3-judge panels. So this was a 3-judge panel that did this. And so you can ask them to rehear and point out their mistakes and ask them to fix them. The other option is a petition for a rehearing en banc. En banc means the whole court. Now, it's not actually the whole court. It has a definition in the local rules. It's like half of the court, and it's all drawn by lottery. So the judges are drawn by, the clerk does a lottery, and the judges are drawn by lottery. So I think it's 10 judges for an en banc review. So you can do one, or you can do the other, or you can do both. And that's what I've elected to do. I've done both. The criteria for either one is in the Federal Rules of Appellate Procedure. I think it's 40. So check that out if you're interested. It's FRAP 40. Just Google that, FRAP 40, and you can see the criteria for either one. I did a combined one, so I had to address the criteria for both in my combined filing. The filing was made today, and I will put a link in the description for everyone to review. Please spread the word. We want the Ninth Circuit to know that a lot of people are watching what they're doing. So take a look at that. Please spread the word. I'll let you know how it goes, of course. I also posted a link to the filing on my post tab, but it'll be in the video description as well. I did this pretty fast, but that's because I've already read most of these cases. So this is the last thing I want to talk about today. I want to warn you guys about using AI for your litigation. A lot of self-represented litigants are using artificial intelligence, and it doesn't work well for them, and it doesn't work well for lawyers either. And the reason is AI lies a lot. It hallucinates. So I did try to use Grock. I have the latest version of Grock, and I did try to use it to help me with this. And in terms of like the English style and writing, it helped, you know, a little bit. It helped me make things concise. I'm sorry my camera's moving, but this is a new style. It's in the car, and I'm just kind of doing an impromptu video on the way to the gym so I can update you guys. If this turns out decently, I'll get some Velcro or something so the camera doesn't move in the future. But anyway, Grock helped make my language more concise. And for the most part, it did a good job on citing to my record, the evidence in my record, and it did a good job citing to cases that I had already cited in my briefs that were already filed. But it did hallucinate and it did lie on a few points. And had I not gone through and checked everything, I wouldn't have caught that. So you have to be very careful with when you use AI in litigation. ChatGPT I have experience with. Grock I have experience with. I haven't used Claude. Some people swear by it. But these AIs, to me, they're just not fully trustworthy. You have to check everything. And in fact, there was a recent case in the Ninth Circuit, and it was on basically family law grounds, where the appeal was thrown out because the lawyer representing the father used AI, and all the cases that she cited were fake. And she got destroyed by the Ninth Circuit at oral argument. So that link is in the description too. I'm almost to where I need to go. I'm gonna go lift some heavy things. So thank you all for all the support. That's the update for today. Boys, I love you. I miss you. I hope I see you soon. I'm very proud of you.